Hello, students. This is Professor Robin McCoy, and it's April 15th, 2020, and we're continuing with Ben Crump's open season, The Legalized Genocide of Colored People. In today's lecture, we're going to cover chapters 4, 5, and 6. So, the conspiracy to discriminate, creating the criminal, and killing them softly. So I did provide you with a PowerPoint to go with this lesson, and you'll see at the beginning of this chapter, Attorney Crump covers Kimba Smith and talks about her situation. And, she had a boyfriend. The boyfriend was up to no good. She got caught up in some stuff. She ended up going to prison, and she got pardoned by Bill Clinton. On page 72, he says, though the 13th, 14th, and 15th Amendments, commonly known as the Civil Rights Amendment, should have reset the scales of justice for blacks in America, time and time again, American institutions quickly nullified that possibility. And so it's interesting enough that he's talking about 13th, 14th, 15th Amendment, because as you know, in this class, we've covered that. We've talked about the 13th, 14th, 15th Amendment, and we've talked about the history, the experience of black people in America from the time of slavery up to the present, how we've evaluated the Supreme Court cases and talked about we've had ups and downs in our experience. And it's interesting that he used the word reset, because a lot of people in the spiritual community and have been and some of the spiritual, metaphysical, have talked about kind of like some of the things that are going on right now, and they've talked about the concept of reset. And so reset is to set again or anew, and that's out of the Merriam-Webster's dictionary. And in this chapter, he also talks about different U.S. Presidents' efforts to nullify the reset that was supposed to have occurred from the 13th, 14th, and 15th Amendment. And so the 13th Amendment prohibited slavery and indentured servitude except as punishment for a crime. The 14th Amendment defined citizenship and required states to provide equal protection for all. And the 15th Amendment guaranteed the right to vote regardless of race, color, or the previous condition of servitude. And then he proceeds to talk on 73 about President Andrew Johnson basically just messing everything up, how he granted forgiveness to the Confederates who directly and indirectly took part in the rebellion. He also restored the rights of Confederates, including the right to vote and all property rights, bestowing on them property promised to former slaves for their suffering or in exchange for their participation in Union War's efforts, and the promise made to former slaves by Union General William T. Sherman of 40 acres and an army mule meant for the first time in the nation's history that blacks in the South could own land and provide for themselves and their families. It says 3 months later, Johnson reneged on Sherman's offer. So he basically nullified the reset. He also talked about how on 74, the Civil Rights Act of 1875, and as we've been covering a lot of this in our race law materials. The Civil Rights Act of 1875 was passed by Congress during the Reconstruction era and promised equal treatment of African Americans in public facilities. In 1883, the Supreme Court struck down the act and ruled it unconstitutional. The court held that the 14th Amendment could not confer on Congress the power to regulate acts of private individuals, in this case, members of the Ku Klux Klan, concluding that the federal government was powerless to correct the denial of African American rights. The sole dissenter, Justice John J. Marshall Harlan, who later would coin the famous phrase, "Our Constitution is colorblind," argued that the 13th and 14th Amendments shouldn't be interpreted so narrowly by the courts as to preclude Congress from protecting the rights of African Americans when the states refused to do so. And then on 75, he talks about in 1871, just 6 years after the ratification of the 13th Amendment in the case of Ruffian versus Commonwealth, the Virginia Supreme Court made no attempt to gloss over the loophole in the 13th Amendment that reads, except as punishment for crime whereof the parties shall have been duly convicted when it declared that prisoners were slaves of the state. The Supreme Court refused to overturn the Virginia court's ruling, thus nullifying the 13th Amendment, and slavery continued under this compulsory labor system in which imprisoned African Americans made products that could sell for a profit. So that's basically what we see is happening today. So I referenced those items in the PowerPoint, and then he also talks about legislative intent, and that's on page 84, and that's actually chapter 5. But you know what? Before we do that, I want to talk about, let's see, he talked about George Bush. So we were talking about the theme of the presidents who nullified the reset. So he talks about George Bush's lack of an immediate response to Hurricane Katrina's, how it resulted in the unnecessary suffering and deaths of Black residents of New Orleans. He talked about long before President Trump's anti-diversity, anti-immigration, anti-civil rights, white supremacist campaign slogan, "Make America Great Again," Coolidge's campaign slogan, "America must be kept American," was a promise he kept by signing the Immigration Act of 1924, which banned or severely restricted immigration of Eastern Europeans, Middle Easterners, and of course, Africans. He also talks about when Dwight D. Eisenhower refused to endorse and was reluctant to enforce Brown versus Board of Education, which desegregated public schools. He explained to Chief Justice Earl Warren that it was understandable that white Southerners didn't want their sweet little girls required to sit in a school alongside some big black bucks. So he talks about Eisenhower. He talked about Nixon launching the war on drugs. He talks about Ronald Reagan, how he vetoed the Civil Rights Act of 1987 and used the phrase states' rights as a dog whistle to condone a state license to discriminate. He talked about Bill Clinton and he took the racial implications of the war on drugs to new heights by authorizing 100-to-1 disparity in penalties for crack versus powdered cocaine. He talked also about what George W. Bush, the 43rd president of the United States, followed in the footsteps of his father's George H.W. Bush, the 41st president, who vetoed the Civil Rights Act of 1990, which was designed to overturn or modify 6 1989 U.S. Supreme Court's decisions that made it more difficult for workers to win lawsuits filed over alleged racial and sexual discrimination in jobs. It's 13 years later, the second President Bush would sign the No Child Left Behind bill, which raised the stakes on racially skewed standards testing practices. And so, again, as we've talked about in our course, we've talked about the Supreme Court. It's just up and down. And, we've talked about what the Supreme Court has done as far as the Black experience. This book here, he's talking about the presidents. Depending on who your president is at the time, it can have a significant impact on Black folks and our experience in America. If we have a president that's for us, then obviously we'll gain the benefits of having that president that's for us. If we have a president that's not for us, there can be some negative consequences that occur. He talks about, in the years following the Civil War, every promise made to Black Americans was broken, just as every treaty signed with Native Americans. Every right received was nullified. Every benefit of citizenship granted the newly freed African Americans was taken back either by the president, just like I just was talking about, and we've talked about in this course. It could be the president, the court, Congress, the state, or private citizens whose actions were without any legal consequence according to the Supreme Court, a conspiracy of the first order. He asked the question on 81, what does the current Supreme Court suggest in the way of legal gains for Blacks? So it says, the Supreme Court has the authority in the 14th Amendment to be the nation's moral compass. By staying centered on principles of equal justice and due process, the Supreme Court can make certain that the elected branches don't throw away our high principles. So, and then you have right now, they're talking about the Supreme Court. If you've followed in the news, they're going to come back in May. They're going to be online, and they're going to be dealing with some issues that are really that are pertinent to all of us, like talking about Trump's, like whether we can find out about his his tax records and things like that, and also talking about how the elections, how making sure that everybody has justice. I mean, I don't know if you guys have heard about in the news, they've talked about what happened in Wisconsin, how there was a recommendation from the government to shut things down, but then the legislature kept things open because they wanted to keep a conservative judge on the Supreme Court, and ultimately they didn't prevail. They were able to get a Democrat on the bench, but they still put the public at risk by having them out there. And then there were a number of polling places that were closed down, and people had to wait in lines for long periods of time and without being able to do social distancing. But in that situation, you did see that despite the efforts to oppress the people, of the state and Black folk and the right to vote, that the voters still prevailed. So that was a positive result. On 82, he talks about the Prigg versus Pennsylvania, which we've read in the race law book, and it's an 1842 Supreme Court case. The court had ruled that the Federal Fugitive Slave Act trumped a Pennsylvania state law that prohibited blacks from being kidnapped from the free state of Pennsylvania into a slave state. With this ruling, the United States Supreme Court established the precedence that federal laws trump state laws and established that runaway slaves had to be returned to their slave masters no matter what the state law was. And it says, when federal laws were amended to give more civil rights to minorities and state laws were more hostile to minorities, the Supreme Court abandoned its precedents and started accepting arguments advanced on state rights. So again, like we've been talking about from the beginning of the course, the Black experience in America has been a roller coaster experience, particularly with the Supreme Court. We've had ups and downs and all arounds. It's all political. It all depends on who's in the office and whether they have our best interests at heart. So that's why, we have an election cycle coming up, and I want to make sure that you guys are all engaged in looking at these people that are running for office to make sure that we put the people in office that are truly for the people and not just for themselves. So now we're going to get to chapter 5, creating the criminal. And so for that, let's see. In that one, he talks about the experience of Irvin Leon Edwards, who was wearing baggy pants and got tased. And he talked about how he was a victim of legislative intent. And legislative intent, as you can see from the PowerPoint, I said it's a law passed not to target a crime, but to cast a group of citizens as criminals. Jim Crow laws. That's on page 84 of Open Season. And then he talks further. He says, Civil Rights Act of 1964 and Voting Rights Act of 1965 overturned Jim Crow laws, but subsequent legislation came along that was just as discriminatory. Lawmakers have long used the power of the pen to discriminate against minority groups in order to uphold this country's dedication to white supremacy. And, I've talked about this before. Specifically in Michigan, you have these laws. It's a contradiction. They say in some instances that you can open carry in certain places, but you also have, I've had a number of clients, mostly Black, some white folk too, though, who get caught up for carrying a concealed weapon. They don't understand that you can have a gun in your car in a lockbox and the bullets separately in the trunk, but you can't just have it in your car without having a permit to carry. And these are some laws that actually disproportionately affect Black people. Felony firearm, saying that you can't have the felony in commission can't have a gun in the commission of a felony. Like you have somebody that has some marijuana, and if they have a certain quantity of marijuana, they get charged with delivery manufacturing. They get charged with that felony, and then if they have a gun, they get charged for having a gun, and they get charged with felony firearm. That's automatic 2 years in prison. And these laws are disproportionately affecting Black folk. And you see in Michigan, we've legalized marijuana. We do have some expungement legislation that's pending, but it shouldn't. I know we have a Republican legislature, which I know that there are some Republicans. My understanding is that there are Republicans that are they want to expand the law. I've also, it's my understanding that there's been some prosecutors and police officers organizations that have been wanting to restrict that, which I just don't get it. I've heard about that in Ohio, they have more progressive expungement laws. They understand that, okay, people make a mistake, but just because you make a mistake doesn't mean that it should be with you for the rest of your life. You should be able to have the opportunity to redeem yourself. You know, you get your right to vote. You can get your right to vote in Michigan, but you should be able to redeem yourself as far as getting your record cleared and being able to get education, access to adequate housing and employment. And I mean, because otherwise, if you can't, then you're going, some people reoffend, they get caught up in the system again. And people don't have jobs, they're homeless. It just creates a whole mess. And in chapter 5, again, creating the criminal, the distinction in sentencing, he talks about the distinction in sentencing between crack and powder cocaine, and most recently, the disparity in treatment with respect to the opioid crisis. So that, we're going to go to that on 92, the book. He says, if you're a black baby born today, you have a 1 in 3 chance of spending some time in prison or jail. If you're Latino, it's 1 in 6 chance, and if you're white, it's 1 in 17. And back to that point about the disparity, let's see, 92. Let's see. He talks about on 92, he talks about how in the black community with crack cocaine, there were stiffer sentences for black folks, whereas with white folks, there was a discrepancy. There was not as severe penalties. And, you know, with the opioid crisis, that there's been a lot, you know, it's been less stringent. They're putting more funding in programming, alternative programming and treatment as opposed to locking people up. So he says on 92, where were these programs, this type of education, funding, and outreach when black communities were affected by the crack epidemic? Where is the restorative justice for black people who were disproportionately arrested for drug offenses because of addiction issues? Why was crack, when it took hold in the black community and tore apart families and neighborhoods, not seen as a medical crisis requiring empathy and outreach? When we look at the response to the opioid crisis versus the response to the crack epidemic, the evidence seems clear that the intention was to target and punish one group of people and to aid and support the other. And it says, have we seen in far too many instances, cunning legislation can target and disproportionately affect a particular segment of the community. Once a group is criminalized, it makes it easier and generally acceptable to profile, harass, imprison, brutalize, and more frequently directly or indirectly kill members of that group. The American Civil Liberties Union defines racial profiling as targeting individuals for suspicion of crime based on the individual's race, ethnicity, religion, or national origin. Though racial profiling is well documented as a practice in policing blacks, it also applies to Latinos, Muslims, and those of Middle Eastern descent, as the war on terrorism and against non-white immigrants continues to stoke fears in the minds of the American public. And he says, this is on 93, a 2018 U.S. Department of Justice special report, Contacts Between the Police and the Public, 2015, reveals that blacks were more likely to be stopped by the police than both whites and Hispanics, and that blacks and Hispanics were most likely to have multiple contacts with the police than whites in both traffic stops and on the street. So he talks about the racial profiling, and then he talks about what in New York, how they implemented stop and frisk, and how it had a disparate impact on black folk. At the height, this is on 96, at the height of the program in 2011, the NYPD stopped people on the streets an astonishing 685,000 times, up from just 97,000 a decade later. This meant that the police could stop individuals in heavily policed neighborhoods without calls multiple times within a given year. Although the actual statistical effectiveness of stop and frisk in reducing crime is questionable, in the 1968, the U.S. Supreme Court ruled in Terry versus Ohio that the 14th Amendment protection against search and seizures was not violated in cases where the police stopped and frisked someone without probable cause to arrest if the police officer had reasonable suspicion that the person had committed, was committing, or was about to commit a crime, and a reasonable belief that the person might be armed or presently dangerous. Police officers in New York and around the country knew that they had been granted limited discretion to initiate weapon searches if the officers believed the subjects to be dangerous. That ruling lowered the standard of proof in these cases from probable cause to reasonable suspicion. So, and he does talk on 101 he says, laws are not perfect. We will never legislate our way to a post-racial and discrimination-free America, but we can create new standards that are less systematically and institutionally biased to benefit one segment of the population while denigrating and discriminating against others. So I would say that's more of like the vision of what can be. Chapter 6, Killing Them Softly. So in that, on page 103, he says, thousands of young and Black and brown people are killed every year, spiritually if not physically, through racially biased judicial rulings in American courtrooms. Police write dishonest probable cause affidavits. On that, that's what our criminal defense bar in Wayne County, we've been trying to work with other attorneys to identify police officers that are known to lie and putting together a list of police officers that we know to lie to make sure we get that those police officers, get reprimanded or lose their jobs if they're lying on people and forcing innocent people to be locked up. Prosecutors, it says, so police write dishonest probable cause affidavits, prosecutors justify charging them with felonies, and judges hand down excessive multi-year sentences of prison and probation. That's on 103. On 106, he says prosecutors retain wide discretion in whom to charge and what charges to bring. No matter whether it is the judge, the prosecutor, or the police on the streets, the end results are always the same. People of color get the most injustice and the least justice. Your local elected prosecutor is a critically important factor in this tragic equation. And then he talks about what happened with Michael Brown. That's on 106. So he talks about 106, a grand jury ultimately chose not to prosecute Officer Darren Wilson, who shot and killed a fleeing Michael Brown of Ferguson, Missouri, though his hands were raised in surrender. And so pay attention, because I did include a video of Michael Brown, talking about Michael Brown and Eric Gardner. So it says, in the Brown case, one of the first occasions when the public could view the inner workings of a grand jury, it was evident that the prosecuting attorney, Robert McCulloch, was taking questionable liberties. According to a December 16, 2014 Vox article, McCulloch had allowed a witness who corroborated Wilson's story to testify as to what her boyfriend saw, although she may have not seen the shooting at all. He suggested in a press conference that the grand jury's decision was a result of an unreliable eyewitness testimony. And it also says, just a week after that decision, the Staten Island District Court's office announced that a New York grand jury chose not to indict Daniel Panatelio for the chokehold death of Eric Gardner, a 43-year-old father of 6 who was approached, tackled, and choked to death by the police for selling untaxed cigarettes on July 17, 2014 in Staten Island. He talked also about an effort by Hank Johnson to put forth a grand jury reform act to ensure that those who are responsible for the use of excessive force be brought to justice, which unfortunately didn't pass, but that's that's something that to be thought of, something we should be working on in the future. Connick versus Thompson, he references on 108. It's a Supreme Court case decided on whether a prosecutor's office could be held liable for a single Brady violation by one of its members because the office provided inadequate training and vital evidence had been withheld. A Brady violation occurs when the state attorney or prosecutor fails to disclose exculpatory evidence that would prove the defendant's innocence. Unfortunately, as relayed on page 108, the Supreme Court ruled that the prosecutor was not liable. And so this was a case. It was a case against John Thompson, a 22-year-old African-American father of two. And so basically he was charged with attempted armed robbery and subsequently murder. And then it's basically, in reading that's on 107, 108, you find out that he was innocent, and he went, he was wrongfully convicted. And then his family, he ends up being vindicated. They get evidence to show that, that he was innocent. So it says here on 108, it turned out that Connick's office, this is the prosecutor, suppressed a critical blood sample test. It was a blood splatter that was found on the victim from the perpetrator of the robbery. It was evidence that the perpetrator had a different blood type than Thompson. Thompson could not have been guilty. He had been wrongfully convicted of the robbery. Remember, it was this conviction that prevented him from defending himself. In his 2002, his murder case was vacated. So basically, and he was retried. His defense provided evidence that was someone else who had committed the murder. After nearly 22 years of wrongful imprisonment, Thompson was finally found not guilty in the retrial. So then his family, it says Thompson would go on to sue the prosecutor, Connick, and several of his assistant district attorneys for suppression of evidence, and won a verdict of $14 million. However, the U.S. Supreme Court in the 2011 Thompson versus Connick would overturn the $14 million. The Supreme Court ruled that the prosecutor's office was not liable. Again, students, we talked about this before. I know if you watch there's a documentary and a movie on Ruth Bader Ginsburg, and she talks about a vision of having all women on the Supreme Court of different colors. We haven't had Michigan. Michigan still needs, we haven't had a black woman on the Michigan Supreme Court. We haven't had a black woman on the U.S. Supreme Court. I mean, this is a problem. We need to have people in office or in positions of power that are going to look out for us, that are going to look out for people who are mistreated. Attorney Crump further goes on to talk about the Freddie Gray case and kind of looks at some of the discrepancies with the Freddie Gray case with this other case that we just talked about, the Connick versus Thompson. So it says, he talks about that on 109. Taking this into consideration, so he says so I'm going to go a little bit earlier. In the Connick case, the Supreme Court ruled that the white district attorney, Harry Connick Sr., could not be sued, though it had been proven that his office had withheld critical evidence that would have exonerated John Thompson, a black man charged with murder. This decision established an important standard when it concluded that prosecutor's office cannot be held liable for the actions, even the illegal actions of one of its prosecutors. Taking into consideration, why are 5 of the police officers who were prosecuted in Freddie Gray's death being allowed to put the state's attorney, Marilyn Mosby, on trial for her so-called malicious prosecution of them? This demonstrates not only are black people routinely killed by police without consequences, but those who seek to hold police accountable may face reprisals of their own, particularly if they happen to be black. Were the rules changed because Mosby, a black prosecutor, had the audacity to charge police officers for killing a black person? And you'll notice in the materials, I did provide you with a video talking about the Freddie Gray situation. And so the participation discussion questions that I would like you to briefly respond to is, what is legislative intent? What was the holding of Terry versus Ohio? And what was the holding of Connick versus Thompson? So we only have a few more classes to go, and we're halfway through Attorney Crump's book, Open Season, which is amazing. And so, as I said, it's so poignant with these times in terms of what's going on. So we're going to finish this book. We're going to have a multiple choice final exam. And just I've emailed you all, and so make sure that you, if for those of you who haven't turned in your essay, turn in your essay. For those of you who have not, I know most of you have, but any of you who have not answered the participation and discussion questions, please do so. If you're having any difficulties or struggles, please let me know. And please remember to, you know, stay safe, stay sheltered in, and again, I'm accessible via phone, Skype, Zoom, Google Hangouts. So just let me know. Okay. Peace and blessings.